Dear colleagues, a fraternal greeting from South America. I thank the Indian Law Society, Law College, Pune, India, for the invitation to participate in this important international summit. I would like to tell you that, with many years of work and research in this area of disability, I can say that universal accessibility is, in my opinion, the most relevant transversal figure in human rights during the 21st century. Universal accessibility involves physical spaces, information, communications, technology, goods, services, products, procedures, both in facilities open to the public or for public use, in urban and rural spaces. Accessibility is universal because it has to do with persons with disabilities, but much further, towards older persons, towards mothers who go with their children in their arms or in baby carriage, to people who have had an accident in their ears, in their vision, and that for a temporary reason they will be limited in this sense. On the other hand, accessibility is a pillar and bridge for the exercise of other human rights such as education, work, or health, and it is also a key factor for the fulfillment of the Sustainable Development Goals according to the 2030 Agenda, for example, inclusive production, peaceful and just societies, and effective institutions that work. As you know, accessibility is enshrined in the United Nations Convention on the Rights of Persons with Disabilities, in a specific article on the matter. It is also a principle, a guiding principle of the Convention, and it is found in the aspect of access to information and communications regarding freedom of expression and information, opinion, and access to communication. In this last case, it makes us see the importance, for example, of sign language as a natural form and expression of the cultural and linguistic identity of deaf persons, an accessible format such as Braille, or audio description for blind persons, augmentative or alternative communication formats such as easy-to-read text for persons with intellectual disabilities, among others. Even the Convention itself assigns responsibilities to the media for accessibility of public information. I would like to say that, in a recent document that I prepared for UNESCO, I point out that access to information and communications is so vital to democracy that the lack of this form of accessibility would bring us within the scope of the Convention Against Corruption, with this one that reflects the figure of transparency. Therefore, this aspect of accessibility is relevant for millions of people in the world, as is accessibility to physical space or transportation. From this point of view, I would like to tell you that I worked for 4 years as chair of the United Nations Committee on the Rights of Persons with Disabilities, and in the review of the initial reports of all the states parties that we consider in that period, in both developed and developing countries, there were always recommendations regarding universal accessibility. This accessibility has been said to be the backbone of the Convention on the Rights of Persons with Disabilities. And notice how important this legal concept has been, that the committee prepared a general comment on universal accessibility, noting that it had a part that supported the fulfillment of civil and political rights, and another part that supported the fulfillment of economic, social, and cultural rights, and whose implementation should be gradual, but constant. And this is very important to keep in mind: gradual, but constant. We also have to point out that this accessibility is related to access to justice for persons with disabilities. Article 13, which tells us that states parties shall ensure effective access to justice for persons with disabilities on an equal basis with others, including through the provision of procedural and age-appropriate accommodations, in order to facilitate their effective role. Not the nominal role, the effective role of persons with disabilities in the different legal proceedings, and whatever the capacity of their participation, including as witnesses in investigative and preliminary stages. Therefore, accessibility is a basic condition of access to justice, and so much so that a couple of months ago, the Special Rapporteur on the Rights of Persons with Disabilities, the Committee on the Rights of Persons with Disabilities, and who speaks to you as Special Envoy of the Secretary General on Disability and Accessibility, we released the International Principles and Guidelines on Access to Justice for Persons with Disabilities, which contains 10 areas, one of which is accessibility. And it is concerned to point out that accessibility for access to justice must be based on universal design, in such a way that courts, police stations, prisons, all of them must be fully accessible, both in lounges and offices, in lifts, in corridors, etc. This accessibility must also refer to information and communications within the administration of justice, to the transportation used to reach the courts or other centers related to the administration of justice, and there must be specific resources destined for the judiciary so that it can make all justice facilities more accessible every day. It is also important to consider the training of those who work in the administration of justice, as well as police officers and prison staff, in regard to the rights of persons with disabilities and, of course, to universal accessibility. This is also an accessibility condition. And having said that, I want to tell you that now, shortly, I am going to issue a document called 10 Fields of Action for an Inclusive Quality Police Service, and that it is intended, as the name says, to the police. One of these 10 areas of action is precisely accessibility in all police spaces, including the transportation used by the police and, of course, access to information and communications. I would like to tell you that all documents that I have mentioned are on the internet, and I will communicate to the organizers the links where you can find them. I would like to conclude this presentation with 2 remarks. The first is that accessibility is strongly related to Sustainable Development Goal number 11, which refers to achieving inclusive cities and human settlements, and refers in particular to public spaces and transport. But also, when the Sustainable Development Goal number 16 refers to access to justice. And why do I say this? Because this has to do with the importance of accountability before the high-level political forum that reviews sustainable development, just as the Committee on the Rights of Persons with Disabilities reviews the implementation of the Convention on the Rights of Persons with Disabilities. And the second aspect, with which I would like to conclude, is that of jurisprudence. Much has been discussed whether accessibility is a right, and I think it is, because that is what the jurisprudence indicates. There are judgments in various courts, and the Committee on the Rights of Persons with Disabilities has also expressly pointed out this when a person with disabilities was prohibited from using a digital device to mark his vote. The lack of accessibility was punished in this case. With this, then, I hope I have contributed to this wonderful activity. Thank you very much.